think that they are destined to fail for the same reason that the big nationwide gender discrimination lawsuit filed against Wal-Mart failed in June, and that is the Supreme Court said that these gender discrimination claims have nothing in common. Different women worked at different stores and were treated differently for different reasons by different local managers. And because of that fact, there's no common issue that binds all of the women together. And if there's no common issue, then you can't bring it as a class action. There's no one is saying that Wal-Mart didn't discriminate. So these are all preliminary procedural questions. The question in the case in June before the Supreme Court, and the question is going to come up in these new cases in California and Texas, the questions there are, what's the proper vehicle to bring the discrimination claim? And the question is it a class action or not? But it doesn't mean, just because the class action was dismissed or decertified, doesn't mean that the claims weren't true. It just means they've got to find a different way to bring the case, i.e. each woman sue on her own, or maybe all the women in one store suing together. But they can't sue nationwide, and I don't think they're going to be able to sue statewide either. Can't bring every case as a class action, and so sometimes you're just out of luck. Now, this particular case, they're relying on a theory of liability called disparate impact. And what that means is it's kind of like statistical discrimination, that you're alleging the company like Wal-Mart has some kind of practice that, even though it's neutral on its face with regard to gender, ends up having a discriminatory effect. And you can show that effect by showing what the pay of women was versus the pay of men. And normally, disparate impact claims like this can be brought as class actions. The problem is that in the typical disparate impact case, you can point to some practice that has led to the disparity. So for example, let's say they were using an IQ test and that led to the disparity, or they were using some other credential. You had to have like a BS or a BA, and that had a disparate impact maybe. In this case, there's no practice that the women are pointing to at Wal-Mart. What they're basically saying is that Wal-Mart's decision to decentralize hiring and pay decisions to local managers has caused a disparate impact. Well, the absence of a practice is not a practice, the Supreme Court said. And so the problem here is that you're left with nothing that unites all the women. There's no common practice, and each of the women was under different local managers and received different treatment. And so there's nothing to bind them together. And we have a class action case with all of them in there. If there's no question that's in common, there's really nothing for the class action jury to do. Because the individual issues will have to be decided individually. The class actions for the common issues, if there is no issue that they all have in common, there's nothing for anyone to do. And so there's no reason to have a class action. The state cases, because different store managers were treating different women differently for different reasons, just combining multiple stores in the same state is going to have the same problem that combining multiple stores across the country had. I think if the women want to go forward, they're going to have to do it one-on-one. They're going to do it individually, or maybe they'll be able to join together all of the women that worked at a particular store. But once you start lumping in multiple stores under multiple managers, I think they're probably out of luck.